We all know our second speaker very well. She's been very active in ABI for a long, long time. She's currently the bankruptcy judge, a bankruptcy judge in the District of Maryland at Baltimore. She was the reporter for the ABI Commission to study the reform of Chapter 11. We also are very, very proud to have her as ABI's Vice President of Research Grants. Ladies and gentlemen, ABI Talks is proud to present Judge Michelle Harner. Have fun.
So good morning. Good, you're all out there. I like that. Before I start, I have to give my usual disclaimer. I'm doing this presentation for educational purposes only. Nothing I say up here can be used against me in any case pending before me in the District of Maryland. So with that, let's get going. What is a small business? Is it a building? A concept? A product? I want to suggest to you that it is so much more than that. A small business, at its core, is the people behind the building, the concept, the product. Most of those people devote their entire lives to the small business. And when that small business fails, when it closes its doors for good, those people lose so much more than any balance sheet could ever show. With our time together today, I want to do three things. First, I want to put some facts around small business failure. Second, I want to talk about the recent steps that Congress took to address small business failure. And finally, I want to think about what lies ahead for small business reorganization. So first, the facts. In the United States, when you look at small private sector businesses, 80% of them survive their first year. Whew, that's pretty good, right? 70% of them survive their second year. Not too bad. But then the story changes. By year 5, only 50% of the businesses are still operating. And by year 10, only 30%. Think about that. For every 10 small businesses that open their doors in the United States, 7 fail. We can't have that. We can't have that because in the United States, small business entities are the majority, the overwhelming majority of all of our business community. And small businesses employ 47.5% of all workers in the United States. Pretty striking. Fortunately, Congress recognized just how important small businesses are and the challenges they face in a Chapter 11 reorganization process, and they gave us a fix. This past summer, Congress passed and the President signed into law the Small Business Reorganization Act of 2019. Now, this legislation did not magically appear out of nowhere. It is the result of a lot of hard work by a lot of people, including the American Bankruptcy Institute and its commission to study the reform of Chapter 11. For example, the commission's study uncovered that Chapter 11 is simply broken for small businesses. It doesn't work. And the commission proposed some reforms. The Small Business Reorganization Act of 2019 starts to implement those reforms. Now, I'm going to refer to the Small Business Reorganization Act as Subchapter 5, because come February 2020, that's where you'll find it, in Subchapter 5 of Chapter 11. Now, Subchapter 5 will cover any entity or individual with less than $2,725,625 in aggregate non-contingent liquidated debt, both secured and unsecured debt. And at least half of that debt, so at least 50% of that debt, has to be the result of commercial and business activity. Okay. The other thing I want to know about the definition of small business debtor under Subchapter 5 is real estate operations are included other than single asset real estate cases. So SARs are excluded, but other real estate businesses could use it. And Subchapter 5 is completely voluntary. You elect to become a Subchapter 5 debtor either on your voluntary petition or within 14 days of an order for relief being entered in an involuntary. Now, think about that definition and think about this. If you look at all Chapter 11 cases filed in the past 4 fiscal years, that definition would cover 40% of the Chapter 11 cases. And notably, in the District of Columbia, Puerto Rico, and 33 states that are highlighted right there on the screen in red, the new Subchapter 5 would cover over 50% of the cases. So there's huge potential in Subchapter 5, and I should note, doing some empirical work in my past, that those data, those numbers, don't capture small businesses who didn't designate as a small business debtor, and it certainly doesn't capture small businesses who chose not to file for bankruptcy because they or their lawyers perceived the system to be broken. Fortunately, all business debtors now have a new toolbox. And Congress, when you read the legislative history to Subchapter 5, built this toolbox to make the process quicker, cheaper, and more effective. Now, I want to dissect each of those, and let's start with quicker. So how is Subchapter 5 quicker? Well, first of all, there's no creditors committee in most cases. The default rule is just no committee. We don't even think about it. And there's no disclosure statement requirement. A small business debtor doesn't have to spend the time or money to try to draft, circulate, and get approved a disclosure statement. I think that's pretty important. So Subchapter 5 eliminates some barriers. It also implements some helpful tools. Okay, and right now, I'm going to say something, and I don't want to hear any chuckling, and I don't want to hear any smirks or snide remarks, but Subchapter 5 contemplates a helpful trustee. Yes, a trustee that's intended to help facilitate a successful reorganization. So we all need to retrain our brain. This is not your grandmother's traditional Chapter 11 trustee. If you take the time to read Section 1183 of the Code, a Subchapter 5 trustee gets to do things like review and object to claims, make sure the debtor is making plan payments. The trustee sometimes will make distributions under the plan. It sometimes can make adequate protection payments to the secured creditors. Most importantly, 1183 subsection 7 specifically tells the trustee to help the debtor develop a consensual plan of reorganization. The only time the Subchapter 5 trustee gets to investigate the debtor is if a party in interest requests and the court approves the trustee taking such action. The trustee doesn't operate the business. The Subchapter 5 debtor is a debtor in possession. So it's a whole new world of Chapter 11 trustee we have here in Subchapter 5. The commission called it an estate neutral. I kind of like that term better, but I'm biased. But you really need to look at 1183 and see what the trustee is there to do. The other helpful tool is in Section 1188 of the Code. There's a mandatory status conference, an early case status conference within the first 60 days of the case being filed. The debtor, the trustee, and maybe other parties in interest have to appear before the court and tell the court what's going on. So let's talk about the path towards a plan before the case derails. Let's get in there early and talk about it. And to facilitate that conversation, the debtor has to file a report 14 days before the status conference. Now that report is not a disclosure statement. What 1188B says is the report needs to detail the debtor's efforts to achieve a consensual plan of reorganization. Now, I don't know what they have to file if they're not going to do a consensual plan, but we won't go there. But it's just, it needs to tell the court what you've been doing to think about a consensual plan of reorganization. Okay, so those are some of the ways that Subchapter 5 can make the process quicker. Hopefully from that, you can see how there can be cost savings in a more streamlined plan. So I'm not going to spend a lot of time on how it's cheaper, other than to highlight one thing on the screen behind me. There are no U.S. trustee quarterly fees in a Subchapter 5 case. For all of you small business lawyers out there, start calculating those fees under the new statutory guideline and think about the savings. No U.S. trustee quarterly fees. That's pretty big. Finally, let's talk about how it's more effective. And this is really the heart of Subchapter 5. And here I want to focus on the plan process. So under Section 1189 of the Code, only the debtor can file a plan. Under Section 1193 of the Code, only the debtor can modify the plan. And yes, under Section 1189B of the Code, the plan has to be filed within the first 90 days of the case. But remember, that plan can be modified anytime before the confirmation hearing. In addition, 1189B tells the court that the court can grant an extension of the 90-day deadline if the delay is not attributable to the conduct of the debtor. Now, I'm not quite sure what that means, but we'll figure it out. And the important thing to recognize is that there's flexibility in the plan process. Remember, Congress did not mean Subchapter 5 to be a beltway to demise for these small businesses. They meant it to be a path to success. So there's flexibility in filing a plan, modifying that plan, or perhaps getting additional time to file the plan. Now, there's two types of plans under Subchapter 5, consensual and non-consensual. We're familiar with those terms. Importantly, Subchapter 5 incentivizes the debtor and other parties to try to get to a consensual plan. How does that happen? Well, for example, if you confirm a consensual plan under Section 1191A of the Code, the debtor, whether an individual or entity, can get an immediate discharge upon confirmation and the effective date. That's a huge change, especially for the individual Chapter 11 debtor. In addition, if it's a consensual plan of reorganization, the trustee's services are terminated unless the plan provides otherwise. Now, Congress recognized not all cases can end singing Kumbaya, right? Not all cases will be consensual. So the small business debtor can confirm a non-consensual plan. And here, Section 1191B gives us a new standard for cram down. In the Subchapter 5 case, you do not need an accepting impaired class of creditors. In the Subchapter 5 case, to confirm a plan on a cram down basis, it has to be non-discriminatory and it has to be fair and equitable. But there's a new definition of fair and equitable. For secured creditors, it's largely the same, the 1129B standard. But for unsecured creditors, a plan is fair and equitable if the debtor devotes its disposable income for a period of 3 or 5 years to be determined by the court to the payment of claims under the plan. New definition of disposable income, which accounts for the costs and expenses associated with running the business. Also, I encourage you to read the language of 1191C because it's interesting. It suggests that a Subchapter 5 debtor can cram down a plan by paying the value of the debtor's projected disposable income for 3 to 5 years. It doesn't say you have to pay that over 3 to 5 years. You just have to pay the value. So can you pay it in a lump sum? Can we do some exit financing? Can we get the debtor out quicker? Maybe. There's potential, there's flexibility, there's opportunity in the plan provisions. Most importantly, whether your plan is consensual or non-consensual, those people I talked about in the beginning of this presentation, they get to keep their business. The absolute priority role, as we know it, is different in Subchapter 5. The LaSalle problem, really kind of gone. Equity can keep its ownership coming out of bankruptcy. That's huge for small business debtors. That's huge. So let me close with a few thoughts. Is Subchapter 5 perfect? No, not even close. Does Subchapter 5 solve all of the challenges that a debtor faces under Chapter 11? Of course not. Is Subchapter 5 a step forward towards helping small businesses turn financial failure into another opportunity for success? Absolutely. And yes, there are questions and there are open issues, but I think that's to be expected with any new piece of legislation. How often does Congress hand us a completely new subchapter of bankruptcy law? How can you not be excited about this? What an opportunity we have before us. And those questions and that uncertainty about this law are only going to be answered by practitioners, businesses, and courts working to implement Subchapter 5 come February 2020. So my friends, the utility and the evolution of Subchapter 5 are in your hands. I look forward to seeing what you do with it. Thank you.
Really good. Thank you. Thank you, Judge Harner. That was phenomenal.